proceed, Your Honor? Madam Chief Justice, and may it please the Court. My name is David Ramos, and I rise to represent the petitioner, Mr. William DeNolf. I will be arguing the application of involuntary manslaughter against Mr. DeNolf violates his right to free speech under the First Amendment. One of the fundamental purposes of the First Amendment is to protect individuals from the government's attempt to restrict speech because of its quote-unquote harmful message. And so today, we ask this court to reverse the lower court's decision for the following two reasons. First, application of involuntary manslaughter is an entirely content-based application of the law. And second, application of involuntary manslaughter is not narrowly tailored to serve the state's interest. Speaking to my first point, when the decision of whether to prosecute an individual rests entirely on what he or she says, the restriction on speech that results is content-based. Because the state of Olympus is prosecuting Mr. DeNolf wholly because of what he said to Ms. Bronner, he faces a content-based restriction that must survive the most rigorous of scrutiny. This court has long established that content-based restrictions are of a fundamental purpose of the First Amendment to protect against. In Police Department Chicago v. Mosley, as cited within Melker-Dinkle, the First Amendment establishes that above all else, the government has no power to restrict expression because of its message, its ideas, its content, or its viewpoint. And that is exactly what the state of Olympus is doing to Mr. DeNolf today.
Counsel, is it significant that the statute doesn't have any content-based language within it?
No, Your Honor, that is not, because the way it is applied in these circumstances is entirely content-based, as it is fully dependent on what Mr. DeNolf said to Ms. Bronner. Had Mr. DeNolf not been suggesting Ms. Bronner kill herself, surely the statute would not have been applied. And that is the definition of a content-based application. This court has identified the difference between content-neutral and content-based applications in much of the First Amendment jurisprudence in this court, specifically United States v. O'Brien. In United States v. O'Brien, this court ruled that the incidental burden on petitioner's message that he was trying to send by burning his draft card was constitutional because the state was prohibiting a specific form of conduct. The conduct was composed of two aspects: communicative and non-communicative components, and they were easily separable. And the state could punish the non-communicative components while being indifferent to the communicative ones. In that case, the non-speech aspects were burning a draft card. The state had a law that prohibited burning a draft card, and Mr. O'Brien did so. And that was what he was being punished for. It didn't matter what message Mr. O'Brien was trying to send, nor that he was trying to send one at all. The state was punishing the conduct. However, in our immediate case, the conduct and the speech are inseparable. There is no speech and non-speech components of the conduct that the state is trying to prosecute today. It is prosecuting pure speech. And this is much more in line with the restriction that the O'Brien court referenced in Stromberg v. the People of California. In Stromberg, this court overruled a law that made it illegal to support opposition to the government by displaying a flag in public. This court ruled that such a restriction on speech is not constitutional because the interest in regulating the conduct has arisen entirely because of the government's disapproval of the message that is being sent. And that is much more analogous to our case today than O'Brien.
Counselor, but isn't there a great interest in regulating suicide or preventing suicide?
Certainly, Your Honor. However, the interest in the state in applying the statute against Mr. DeNolf today arose because of what he said to Ms. Bronner, and that is the interest that this court should analyze. And that brings me to my second point. Because this is an entirely content-based application of the law, the state must survive strict scrutiny in order to justify it, and the state fails.
Counsel, if we find that this law is in fact content neutral, how does that affect DeNolf's case today?
Your Honor, we would still win because if this court were to rule that this was a content-neutral application of the law, the state would still have to pass the O'Brien test. And the last prong of the O'Brien test is that this is the least restrictive means necessary to promote the state's interest. And that is the prong that we are arguing the state cannot satisfy within strict scrutiny. The only substantive difference between the two tests is the level of the interest required. And we concede that the state does have an interest in this case. This court has long established that suicide and protecting its citizens is of the utmost importance, and we do not contend that it isn't. However, when there is a less restrictive alternative that the state can utilize to promote its interests, The Constitution demands that the state use that.
And what would you suggest for it to be narrowly tailored, for example?
Your Honor, we suggest that an ulterior way the state could promote its interests is by making suicide illegal, something that states across the country have done, as cited in Milker-Dinkel. By making suicide
Have they
illegal.
done it successfully and constitutionally? Is it?
Yes, Your Honor. The legislature in Minnesota decided to repeal it, but it wasn't a constitutional issue. It can be done, and by doing so, the state of Olympus would be able to utilize previously outlined exceptions to the First Amendment that have well-established jurisprudence to prosecute the speech that it is attempting to punish today.
Counsel, if the state of Olympus made suicide illegal, I believe within our case law there's a case where assisting suicide is illegal. Is that, or was unconstitutional, is that correct?
Yes, Your Honor.
So if they prohibited suicide, but they could not touch assisting suicide, it seems that today the state of Olympus would still have no means of prosecuting Mr. Denolf under that statute that you're suggesting. Is that coherent?
Your Honor, 2 points on that. First, the case you are referencing, Milker-Dinkel, the Minnesota Supreme Court actually ruled that it was constitutional to prohibit assisting suicide, but it was unconstitutional to prohibit encouraging or advising suicide. Exactly what the state of Olympus is doing today. And the second point on that is that by making suicide illegal, the state can utilize the speech integral to criminal conduct exception that this court outlined in Gibbon v. Storage Empire and Ice & Co., as well as incitement to lawless action, which was outlined in Brandenburg v. U.S. If suicide is illegal, Mr. Denolf's words can definitely be considered inciting the legal action of suicide. Also, if suicide is illegal, they can definitely be considered speech integral to this criminal conduct. However, in the absence of a law prohibiting suicide, a rule in the respondent's favor would be expanding the categories of speech that have previously been unprotected, and this court has expressed how wary it is of restricting First Amendment freedoms when there are already pre-existing categories that do so. By ruling in respondent's favor, this court would be expanding the speech integral to criminal conduct category to include conduct that the state simply deems as harmful. This would have an impermissible chilling effect on speech because it would require citizens to make assumptions about what conduct the state views as harmful.
But don't you think that if we side with you today, don't you agree that it would create a slippery slope? But then we have to accept, this type of speech and many other people just, basically inciting others to go kill themselves?
No, Your Honor, we don't believe that a slippery slope would occur because the state has means to restrict this conduct. It just isn't utilizing them. And that is unconstitutional under the First Amendment. We argue that should the state pass a law prohibiting suicide, that this would be a different case. Mr. Denolf would not only be encouraging illegal conduct, his speech would play an integral role in that criminal conduct, and it would not be protected by the First Amendment. However, because today, suicide is a legal act in the state of Olympus, Mr. Denolf was simply encouraging Ms. Bronner to commit a legal act. And this is not prescribable under the First Amendment. And the state of Olympus cannot satisfy the most rigorous of scrutiny to justify its application of the law here. The First Amendment ensures that individuals have the right to speak their mind without fear that the state will prosecute them because it disagrees with their viewpoints. As distasteful as his speech may have been, the state cannot constitutionally prosecute Mr. Denolf because the First Amendment protects his speech. The Constitution explicitly protects against such content-based applications of the law, and to hold otherwise would be to render the First Amendment toothless. And for the aforementioned reasons, we request this court reverse the lower court's decision.